Start off with our first session, and I request respected Regional Council Member Vikas Jain sir to welcome Dr. Risham Garg sir with a memento. And again requesting Vikas Jain sir to welcome Anoop Rawat sir as well with a memento. It's my now honor to introduce Dr. Risham Garg. Sir is Associate Professor of Law and Executive Director, Center for Transnational Commercial Law, Center for Regulatory Studies, National Law University, Delhi. Sir is Executive Director of the Center for Transnational Commercial Law and the Center for Regulatory Studies at National Law University, Delhi. He has co-authored a book of Uniform Commercial Laws and Ease of Doing Business in India and is co-editor of the Journal of Economic Laws and Policy, along with Professor Rebecca Perry and Professor Charles Scott Pryor. He is involved in research, teaching, policy, and consultancy on topics related to insolvency and bankruptcy, domestic and cross-border regulations and regulatory studies, transnational commercial laws, transnational law, ADR, aviation law. He also instructs the Insolvency, Restructuring, and Entrepreneurship Clinic, engaging young minds with experiential education. He regularly speaks in executive and continuous professional education programs of judicial, government, professional institutions. So actually his CV goes in, I think, 4 pages, but with the proximity of time, so with your kind permission, I am not reading everything, and we would like to hear you more. So I request to please address the gathering. And I would also like to introduce the second speaker, Anoop Rawat sir. Anoop Rawat sir is a partner with a firm with over 20 years of experience and specializes in insolvency and bankruptcy projects, banking and finance. Especially in insolvency and bankruptcy, sir boasts of having representing clients across various capacities, including resolution professionals, the committee of creditors, and the resolution applicants. He has been instrumental in development of the insolvency jurisprudence in India through effective legal representation of different stakeholders in complex and unprecedented insolvency matters in the country, including the first consolidated corporate insolvency resolution process, Videocon, and the first consolidated insolvency process of the financial service providers, SREI. He has played an active role in the insolvency resolution of several of the 12 large corporate accounts who were referred to insolvency by the Reserve Bank of India. He has also represented various foreign portfolio investors, Indian and foreign private equity players, and other strategic investors in evaluating investment through debt, equity, and or other synthetic instruments in India opportunities, and strategizing the investments for such investors, inter alia through asset reconstruction companies and other partners. His notable recognitions and awards include recognized as distinguished practitioner by Asia Law, included in the A list as a part of India's top 100 lawyers and legal icons by the Indian Business Law Journal, recognized as among India's top 100 lawyers by Forbes India, recognized as a highly regarded legal practitioner by IFLR. So big round of applause for both the learned speakers for the first session, and I now hand over the session to the learned speakers. So sir, please, if you could come on the podium.
Good morning to you all. Thank you ICAI Ahmedabad for inviting me, the officials. I mean, it was a wonderful inaugural session. After having heard the wonderful pearls of wisdom from the Honorable Enclad Member, Shri Ajay Malhotra ji, and you know, the bevy of experts, senior office bearers of ICAI, I am at a loss of words how I will start this address. So it's always good, you know, to start with some complex aspects. And I was, you know, hearing Mr. Sumit just a while ago, and he was explaining about Ahmedabad. So there are, some very crucial elements regarding Ahmedabad. One is, not only there is a proximity to certain regions, but you probably will have the largest, most successful insolvency, successful resolution that has taken place in India, and it's going to be very difficult to beat. And we have the man sitting here, Shri Gupta ji is here already, and I'm sure he'll enlighten the audience with his wisdom. Apart from that, why this cross-border insolvency is relevant now, we also have the gift city. And you never know when the foreign law firms will come in, but foreign businesses will come in. And there will be inflow of businesses as well. And there can be action on the cross-border insolvency front as well. So it makes it more interesting and relevant for you to understand and focus upon what is cross-border insolvency. And my dear friend Anoop will also explain about the group insolvency. So my address is on what is cross-border insolvency. So as you understand, if there is a debtor whose assets or working is spread across jurisdictions, spread across countries, then that involves a cross-border element. And when there is a cross-border element, it is not easy to address it in one particular jurisdiction alone by application of the domestic legislation only. So what is the need for a specialist cross-border insolvency law? The need is that there will be debtor or assets located across jurisdictions. There will be a need to enforce the orders. So if there is a moratorium, the moratorium needs to be enforced in other jurisdictions. And likewise, there is a need for insolvency professionals to have access to the court processes. And for that, a separate, robust legal ecosystem is required. And that legal ecosystem, a specialist ecosystem, is in the form of a model law. So now what is the model law which has been created by the UNCITRAL? Now this is basically for cooperation and coordination. It lays down some framework where there can be an application of law, ease of transactions, ease of the resolution process, and better coordination amongst the professionals, practitioners, and also the courts across the jurisdictions. Now, what is the model law on cross-border insolvency and why it was drafted, and then what is the situation in India? So as you can see here, and as I have already explained to you, that the model law is required. So what is UNCITRAL? We have to understand what is the purpose of some of these bodies. So there you understand there is UN, and the legislative body of UN is UNCITRAL, but UNCITRAL specifically focuses upon legislations or laws to assist the international trade. So the focus is that they are promoting and drafting laws in the interest and furtherance of trade. So they are a focused trade or business related organization. Now the Ministry of Corporate Affairs, they have released the draft part Z, which is based upon the UNCITRAL model law on cross-border insolvency. And reading the draft part Z, starting the article 1 itself says that this part is to adopt and incorporate the model law on cross-border insolvency into India. So even though in 2016, when the IBC was drafted and was deliberated upon in the parliament, and some parliament members raised that we should have a robust cross-border insolvency regime as well, at that time, although a compromise was adopted in incorporating two sections, 234 and 235 only. However, it was felt that for adopting cross-border insolvency, further detailed deliberations are required, and it will be adopted in due course of time. So the ministry showed this promptness, and in 2018 itself has taken a decision to adopt the model on cross-border insolvency in India, and it just awaits the notification from the Parliament. Just, I'm a academic, so I'll always like to explain the fundamental aspects. So how do we understand the nature of these laws which are drafted by these international bodies like UNCITRAL? So you may have read some international laws which are termed as convention, and some is termed as a model law. So what is the difference? So a convention is a law, and it has to be adopted as a law as such. And the model law is an example, that is a draft law which any jurisdiction can adopt in their jurisdiction by incorporating it completely or making suitable changes to it. So there is no need to implement that model law as it is. There is a freedom to make those changes. And the best example for these, for the convention, is the Foreign Awards Recognition and Enforcement Act of 1961, which adopts the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards of 1958. So which recognizes, creates that ecosystem to recognize and enforce foreign arbitration awards in India. So it is based upon a 1958 convention. Then a popular example of a model law which has been adopted in India is the Model Law on International Commercial Arbitration, which was referred to when the Arbitration and Conciliation Act of 1996 was enacted. Now, again, we have an example. There is a Cape Town Convention. That is a convention, and it is sought to be adopted as the Protection of Interest in Aircraft Act. So the bill has already been is drafted, that was in 2002, and I'm sure it will be taken care of in good time. So what is the UNCITRAL model law on cross-border insolvency? So basically we need to understand what is the focus of the model law, or what is the focus, what do we require in cross-border insolvency legal regime. So there are four main principles. So first is that there must be some access to the foreign insolvency practitioners. So if you as an IP in India want to go to a foreign country, you must have that right to access. Similarly, a foreign insolvency professional, when they want to come into India, they must also have that right to access to the courts, to the court system. Sometimes some countries follow the process or the principle of comity, and considering the principle of comity, countries may recognize foreign orders or judgments, but it's again discretionary. A country may just say that best example is the case of SEL. So SEL, the insolvency was admitted in India, Chandigarh, and there were some assets in US. So the insolvency professional wanted to go to US. So it was not similar to the case of JET, where the JET insolvency was brought into India for recognition and enforcement, and the NCLT mentioned that we do not have any cross-border insolvency legal regime, so we are unable to recognize your insolvency order. However, the US court, US Bankruptcy Court, recognized the India NCLT order moratorium and the appointment of the IP, the RP, on the basis of the principle of comity. So it is discretionary upon countries. There is no hard and fast rule that you should, you cannot, they can also decline. They may exercise their discretion. So as is evident in the two illustrations I have just provided. So the relief is there, and interim relief is always at the discretion of the court. In several circumstances, all the IPs are aware there are several situations where you require interim relief, and at those instances, the court recourse is needed. Now, taking some key provisions of the cross-border insolvency draft law, it is going to be in a place in India, and we assume that the draft law in its form will be adopted mostly in the way it is. There may be minor changes, but for now, whatever is in the draft model, draft part Z, those provisions I am explaining here. So what is the applicability of cross-border insolvency regime in India? This will be subsequent to the draft part Z being incorporated into the code. And again, it's a draft part Z. Part Z means it will be incorporated into the code. It will not be in the form of a regulation. It will become a part of the code itself. So the code provides the AA with the power to refusal to take any action for implementation which in its opinion ought to be manifestly contrary to the public policy of India. So this is a fail-safe provision that in case the adjudicatory authority feels that the foreign insolvency proceeding which is brought for recognition and enforcement in India might be held to be contrary to the manifestly contrary to the public policy of India, they may refuse to enforce it. So public policy exception is a fail-safe, and it's there invariably in all the jurisdictions. However, the qualification, it is further qualified by the term manifestly, which imposes a greater burden upon the applicant to disprove. So the presumption is in favor that yes, it will be recognized. However, if the government wants to disprove that there is something contrary to the public policy, they may go ahead. Then the foreign representative has to apply to the adjudicating authority, and it is mentioned that all the adjudicatory authority will be entitled to entertain these provisions. So we are yet to see whether it will be a few designated benches. However, the indication is that all the NCLT benches may have that jurisdiction. So it is, as of now, because only the corporate insolvency provisions part are in force in India, hence the cross-border insolvency will be applicable only to the corporate insolvency and not to those aspects, for example, the personal debtors or the financial institutions for which there is no special insolvency provision as of now notified. So all the benches of NCLT to be vested with the jurisdiction to deal with the applications under Part Z. But insolvency proceedings pertaining to foreign companies will be dealt only with by the principal bench of the NCLT. So now what is the framework, what is required for the insolvency professionals? The foreign representatives will be given access to the insolvency system and the infrastructure in India for the purpose of cross-border insolvency proceedings. And the foreign representatives acting in the cross-border insolvency proceedings will be required to undergo some sort of a minimalistic authorization process with the board, which will be some sort of a deemed authorization. So there are apprehensions. In some countries, there are registered, there are licensed, there is an oversight mechanism, some regulatory body is there, but in some countries there is none. So in US there is none, there is no agency. Anybody can act, any professional can act as a insolvency practitioner. So there will be some standards for regulation of the foreign insolvency practitioners as well. So there will be a principle-based light touch code of conduct to be applied to the foreign representatives. And the board will be empowered to undertake investigation and disciplinary actions against misconduct by the foreign representatives. Now, the issue is what are the types of proceedings and when it will be filed. Now, it is based on a concept which is called as center of mean interest or the COMI. So it is basically, if there is, like we understand what are the grounds for any NCLT to assume the jurisdiction, or the question is where will the insolvency application be filed. So the answer is wherever the registered office is located. So this is the concept behind the COMI, that wherever is the center of main interest and the presumption is in favor of the registered office of the corporate debtor. But that presumption can be displaced by some other factors. There may be a registered office in a foreign country, but there may be major assets in India, there may be a major establishment or assets in India, and which may involve the application be filed in India. So to take care of those aspects, it does not specify directly that the insolvency application for cross-border will be filed only in a jurisdiction where the center of main interest, that is the registered office, is located. It says it should be center of main interest and presumption goes in favor of the registered office, but which can be disproved as well. And the code also says that there might be a situation where a debtor company might be apprehending insolvency, maybe in distress, and they might change their office to a foreign jurisdiction. So the code also provides a look-back period of 3 months. In case the registered office is shifted within 3 months, then that aspect will be ignored. So some indicated suggestions or guidelines are provided by the MCA in the draft itself, which goes on to say that these are also the factors which can be utilized by the NCLT in determining whether it will be able to assume the jurisdiction on a particular cross-border insolvency which is sought to be recognized and enforced in India. Certain discretionary reliefs can also be given. So the question is that, whether so in this, you are well aware with the case of Macquarie Bank versus Shilpi Cables, whether a foreign creditor can file, and there is no, the decision is that there is no distinction between a foreign creditor or a domestic creditor, and the creditor can file an application in India. There is no dispute, and this is consistent with the old case of 1962, the Raja Vizianagaram case, which held, which could be considered to be the first cross-border insolvency case in India, where the Supreme Court had allowed that foreign creditors are also similar to the domestic creditors, and the domestic creditors will not get any priority over the foreign creditors. So the foreign creditors were able to prove their claims, and their claims were also paid in that insolvency. So another interesting aspect about that case of 1962, Raja Vizianagaram, that it was based upon a protocol. There was no cross-border insolvency law. A protocol was drafted, and similarly, in the case of JET also, a protocol was drafted. So I've just mentioned the case of Cell, and US Bankruptcy Court out of committee recognized the Indian insolvency proceedings. So what happened in JET, interestingly, you are all aware, but just to reiterate, and this could happen. So for the insolvency proceeding were commenced in Netherlands, and the foreign representative who was the liquidator came to India to get that insolvency recognized and enforced. And at that time, JET had not been admitted to insolvency. Had the JET been admitted to insolvency, then the response would have been different. The response would have been that JET is already introduced to insolvency, CIRP is already underway, and hence we cannot recognize the cross-border insolvency application. However, the NCLT mentioned that there is no cross-border insolvency regime in India which enables us to recognize this cross-border insolvency application. So appeal went to the NCLAT, and by that time, the NCLT had admitted the SBI Section 7 application, and a protocol was drafted between the representatives of India and the Netherlands. So this was an example of a protocol where the insolvency-related resolution was conducted. Now, So there are, several cases I can take. I want to just refer to one case. So these are the provisions. So as you can see here, the purpose is evident. This is the draft part Z. The first line says the purpose of this is to incorporate the ancestral model on cross-border insolvency. So second is public policy, and so on. So one interesting case is the Eurofood case, and the question here is that there is a holdco, and the holdco is in a country like Italy, and there is a subsidiary. Subsidiary is Eurofood in Ireland. Subsidiary is admitted to insolvency, and so the bankers want to file insolvency in Ireland, which was the place of registered office, incorporation of the company, whereas the holdco, which was situated in Italy, filed an insolvency application in Italy. So both the courts wanted to continue the insolvency restructuring proceedings in their jurisdictions, which basically were the resolution proceedings, so which will control the proceedings. So there was a conflict, and ultimately in the European Union there is a European Court of Justice which could take a decision that bases certain factors, that the prior in time insolvency was admitted in Ireland, and also the creditors in their loan contracts had mentioned that in case of any issue, the legal proceedings or insolvency will be filed in Ireland. So this was resolved in this way. So we should be mindful. This case gives a very important lesson, which we can also look from the case of Jet. In case of insolvency, you have to act in time, and time is crucial. So this case identifies that whoever files the insolvency prior in time, there must be some reasons. They can continue with controlling of the insolvency process. So another element which was discussed was what are the grounds where registered office presumption can be rebutted, and the grounds usually are that the registered office is in a place which does not have any substantial assets, is like a letterbox company. When we have heard in Kolkata, there are some streets where thousands letterbox companies are there, and there are some tax havens, Cayman Islands and so on, where there are several companies registered without any assets. So in several cases, the courts have considered that just registered office without any substantial business activity or assets will not entitle, or in those circumstances, the presumption in favor of registered office will be rebutted. So again, where we got this 3-month time period look back, if the registered office is to be shifted, so this is the case. Registered office was shifted, and insolvency application was filed in Italy, and the court held that now more than 1.5 years have passed, and there must be a reasonable period. A reasonable period was held to be 3 months. So I will just want to complete with one or two more instances that there is cooperation and coordination. And for cooperation and coordination, there is this judicial insolvency network, and this proposes to create a network of courts, a coordination amongst the courts itself, and this is the JIN, Judicial Insolvency Network, and the judges from India also participate in these discussions. So as and when the cross-border insolvency is adopted in India, there is likely to be a simultaneous cooperation agreement executed between the courts. We recently have heard that the Supreme Court of India has entered into an MOU with the Singapore Supreme Court for some reason. So, you know, this is probably a good start for things to come. Right. So, yeah, thank you for your patient audience, and thank you for inviting me here. And whenever you have questions, you are most welcome.
Thank you, ICAI Ahmedabad branch, for having me here. They've always been very involved, I think, in the issues relating to insolvency. And it's good to see that, you know, they have also engaged the non-chartered accountants to participate in the process of discussions and deliberations on issues surrounding the insolvency law and its development in India. I'm assuming that most of the people here would be the insolvency professionals, and some would be the lawyers practicing the insolvency law. I'm here today to discuss the group insolvency law aspects and how they're shaping up in India. See, once Aristotle said that, you know, the whole is greater than the sum of its parts. And I think that sits very fit with the group insolvency concepts also. It is recognized worldwide that in fit cases, the group insolvency approach is the right approach. I think in India, this is more relevant and critical. As a banking and finance lawyer, I know in most of the cases how nuanced the financing of the groups have been. We have seen cases where if the land is with the parent company, the factory is set up by the subsidiary. If the products are manufactured by one company, the other critical components are by the other. In that context, I think if the group goes into insolvency, then it is, I think, quite obvious that, you know, we should look at the group insolvency approach. Now, as far as the group insolvency approaches are concerned, I think there are various forms of coordinated process. We also call it, we know group insolvency in India as the consolidated processes. It started with the Videocon, where, you know, Videocon had more than 15 subsidiaries, and they used to make the white goods, the TVs, the fridges and likes, and most of their components manufacturing was housed in different companies. So it was the first company which was first faced the insolvency at the individual level, and they had different dates of insolvency commencement, and finally pursuant to the consolidation order passed by Mumbai NCLT, they were consolidated. Now, when we say consolidation, we must understand that consolidation has different connotations. Consolidation could either be a procedural consolidation, or consolidation could also be a substantive consolidation. What I mean by that is that a procedural consolidation does not mean that you club all the assets and liabilities together. A procedural consolidation is more on how you coordinate the processes. And one way to do a procedural consolidation could be that, you know, you have one resolution professional looking at all the group entities together. You could also have the COCs sitting together. You could have the RFRPs, the EOIs, the RFRPs and the plan submission dates together. But in essence, the independent status of the company remains. They don't get consolidated at the balance sheet level. So that's the procedural consolidation. And when we talk about the substantive consolidation, there either we have a full substantive consolidation or we have a partial substantive consolidation. A full consolidation, a full substantive consolidation would mean that you have clubbed all the assets and liabilities together. So it becomes one book. So it will not entail, you know, two different COCs approving two different plans. There will be one plan or one single plan which takes care of all the assets and liabilities together. You could have a partial substantive consolidation also, but so far in India we have seen either a full substantive consolidation, which is more like, you know, what you have in Videocon, where all the claims were filed for the group consolidation. It was quite easy in the sense that all the group entities were co-obligors. So the substantive consolidation was easy there. And we have the other examples of procedural consolidation, which are Shrey. Shrey Group, you would know the entities. There are two entities. One is the equipment finance and the other is the infrastructural finance company. So they have not been, the asset and liabilities have not been merged as such. It only entails procedural consolidation in the sense that you will have different liquidation value for each, the creditor who's sitting at the SIFL and different liquidation value for the lenders who sits at SEFL. Then we have other examples of consolidation involving Lavasa. Then we have most recently seen Region, which has come. In the group insolvency jurisprudence, how we thought of it initially when it came is that it is part of exercise of a commercial wisdom of the lenders. And this is for a very long time. I would say that, from 2018 until I think August end, we thought that, it's all, or maybe, just a month till some month before that, we thought that the commercial wisdom of the creditors drive the consolidation, and as long as the committee of creditors want to pursue the consolidation, then it should happen and NCLT should approve it. And all the cases, initial cases, were around this principle only, including Videocon, including Lavasa, including Shrey. So there you have the consolidation application which were filed either by the committee of creditors or on the approval or the consent of the committee of creditors. However, that jurisprudence is changing. And we have seen, some cases where the courts, the Honorable NCLAT, in Region case, for example, have allowed consolidation to take place despite the opposition from one of the group companies. Now, it's a very interesting development because, what it does is, it establishes the principle that consolidation is a judicial wisdom, not the commercial wisdom. So therefore, while the commercial wisdom could be one of the criteria to see when you look at the request for consolidation, however, even where there are warring creditors who have the conflict of interest, who have their own objectives, but there are synergies of operation, interlinkages, interdependence, and for the sake of a larger resolution and maximization of value, the consolidation must be ordered. NCLTs, or now in Region case and CLAT, they approved the consolidation. It's a very, very interesting development. What it also means is that, the field of applicants are also increasing. When we started this whole thing, committee of creditors used to take initiative. Then in some cases, the resolution professional on the instruction of the committee of creditors have initiated. And then more recently, the operational creditors initiated it. So what it means that the field is increasing, and therefore, as professionals, as resolution professionals, if in a fit case you think, and in fact, there could not be any better person who understand the operationals labyrinth than the resolution professionals, the insolvency professional. If you feel that it's a fit case for requesting a consolidation, then in the interest of maximization of the entity which you are managing, it will not be very, I think, far away that, resolution professional also start making that application. I think we do have a lot of play in the joints. The insolvency professionals here in India, they have much more better opportunity as compared to your counterparts elsewhere in UK, US, where the law is pretty much settled, to try and do some innovative things. And I think if you look at also from a perspective of this as a business or a profession, I think the people or the professionals who can innovate more, who can bring out better solutions, will also be the ones who will be sought after by the creditors and by other stakeholders than the ones who just simply follow what has been happening. India is not a place, as far as the insolvency market is concerned, India is a place where every day the innovation is happening. So therefore, we have variety of cases where we have seen that, new innovative approaches have been adopted by the resolution professionals. And I would say that, as a practitioners, I would also urge all of you to keep looking for innovative ways, especially in the segment of group insolvency, also in the segment of, the cross-border insolvencies that Dr. Garg touched upon. And he also touched upon the matter of Jet Airways, where, the resolution professional, had this thinking of approaching the NCLT to request for an innovative way of coordination between him and the foreign trustee to set out a process of coordinating the whole processes. So, as far as, the Indian scenario is concerned, we do not have any legislation on on group insolvency. Everybody knows it. We had the working group that was set up under the chairmanship of Mr. Sinha. They submitted the report also, but so far it has not been converted into any kind of a legislation. One reason could be that, it is working perfectly well and the jurisprudence is developing anyways. I have been myself personally part of some of the working group deliberations where there was one consensus that, the substantive consolidation should not be put in the legislation, because every company has its unique status. Every company has its creditors, and you cannot force the substantive consolidation on the creditors, and therefore, it should be left to the creditors to decide whether they want a substantive or procedural. However, they should have some guiding principles on how to run a coordinated processes where there is a requirement. And I think therefore, I think even when we do have a legislation on this or a regulation on this, I think those regulation will focus on the procedural consolidation, procedural coordination more than the substantive consolidation. And those procedural coordination aspects, I think, are necessary because, in some cases, the conflict of interest amongst the creditors prevent or restricts their ability to come together and run the process as a joint process. So therefore, there has to be some nudge from the government side or from the regulator side to force them to adopt certain coordinated processes without undermining their respective interest or claims. Our estimate is, or our sense is that, this law will continue to develop. The region matter, which is the latest matter where the NCLAT has ordered the consolidation, despite the opposition seen from one of the committee of creditors, is yet to be tested. I think Supreme Court will finally decide on that. But I think that's the right approach. It's a it's a good sign. It's a good sign. And I must say that, when we go outside, I was in Insol International Conference in Tokyo a few days ago. And everybody praises the way we have carried with our insolvency law so far. While there are certain hiccups, there are certain problems and complications, but yet they are amazed at the speed at which we have adapted ourselves, the speed at which we have, removed the shortcomings. And the intent is there. And, when you compare to somebody like China, where nobody knows what is happening, if you compare it with China and Chinese economy, then, people definitely look at India as a very favorable destination, where, the insolvency law for the first time has allowed even the foreign creditors to come and initiate insolvencies, and they have actually put them at par with the domestic creditors. So therefore, I think we have lot to create. In most of the jurisdictions, they are following the law. I think we can create the law. We can create the processes in India. I think that's the fun of being either the insolvency professional or the insolvency practitioner or the lawyers in India. Have I run out of my time? Okay, sure, thank you. So I would, in fact, if anybody has any questions, so I would leave just 5 minutes for, just an interaction, just to see whether people are hearing or not. I just wanted to touch upon, what is happening elsewhere. In international platform, you have your UNCITRAL model, which was introduced in 2019 on the group insolvency. But, it's not that, it has been adopted verbatim by all the countries. Every country has its own peculiarity, and they do modify, and their municipal courts do interpret them as per the culture of the jurisdiction. Culture plays a very, very important part. And as I said that, our group insolvency processes need to be based on how our groups have taken finances. And it's very, very amazing, when I discuss with some, some insolvency practitioners abroad, how their group insolvencies are structured and basis on what kind of underlying enterprises. And they're quite amazed to know that we have situations where the banks have lent to a company without that company having the ownership of the land, underlying land. And in that context, I think it becomes very important for us to look at our group insolvency processes as very critical processes. I guess what has happened in the insolvency space in the last 6-7 years is the banks have realized that the way they finance the projects perhaps is not the best way to do it, because then they actually faced with a situation where in a disintegrated insolvency process, and I can name the group because it's it's already now resolved. MTech group is one group where if you study the insolvency of MTech group, where forging was in one company and the other aspects of the automotive product was in other companies, they ultimately face a situation where, as a disintegrated process, the realizations were way below what they could have done if they were run as an insolvency process. I think it's a good case study. That's why I said that the whole is larger than the sum of its parts. So Amtech Group is one. The second I can name is the Lanco Group, where you had multiple subsidiaries. You had Lanco Infratech, which was sent to insolvency without sending the subsidiaries to insolvency. This is so bizarre. You can't have a holding company which is only predominantly holding the investments and then doing bit of the perhaps the EPC works for its subsidiaries, to go into insolvency without sending the subsidiaries into insolvency. As a result of which, you had so many of those companies sold for peanuts, the subsidiaries. We recently had the resolution of one of their subsidiaries, Lanco Anpara, which was one of the flagship power project in the Lanco group. So I would say that if you look at how fragmented these insolvency processes have been, it's a waste. It's a waste of the public money, because the lenders end up receiving much lower than what they would have achieved if this whole thing was done in a very coordinated manner. I would say that it also does a lot of harm in moving the capital, because even if the resolution was possible, because of the complications of the group structure, the capital could not rotate and it got stuck for multiple years. And we are now into almost like 6 years of Lanco Group insolvency, and we still not completed that. So I hope that we learn from it, but we have some success stories also, and we will only see it later, how successful they will turn out to be. Shrey Group, which has been now taken over by Narsil, will see that how they carry on with the infrastructure finance business. We have Lavasa, a lot of this different parts of the whole township got consolidated together. We'll see, how it gets revived. But so far, if you look at the performances of all the companies who have been resolved under the insolvency, and there was a study which was issued by one of the IIMs, and it shows very encouraging signs that they have done phenomenally well. We hope that we continue to do more experiments in this, and as I said that keep thinking and keep bringing in innovative ideas in this insolvency profession. Thank you.
Okay, so thank you, thank you, Anoop, for the very interesting and insightful deliberation and articulation on these very complex issues. So I would like your insights, your considered insights on two specific aspects. One is that why is it that before passing of the cross-border insolvency law, there is a need to have in place a mechanism for group insolvency, and this I'm asking in the context of the definition of associate company in the Companies Act and the complications in reaching to a definition of a group company in the Companies Act, or whether the company group company will be only related to insolvencies. And the second is, you have mentioned about Lanco, but just about real estate, if you could also highlight some issues in the real estate groups.
Thanks, Dr. Garg. I think more than the definition, I think the principle of group insolvency is on the basis of the interlinkages of the operations. So for example, if there is one company which is solvent, and the other company is insolvent, we would rather not touch the solvent company. So, I mean, to begin with, just to clarify, I think we are only talking about the group insolvency in the context of the companies which are already in insolvency. And even within the companies of the group which are in insolvency, we are talking about group insolvency only for companies where where there is an interdependence of operation, interlinkages, there is a pooling of the assets, and the maximization could be achieved if you do it in a coordinated way. And that's an immediate requirement for us, more than the more than the cross-border. Because in cross-border, you see, one aspect is that we need to understand that how do we give recognition to the foreign proceedings? How do we come to an understanding that the foreign jurisdiction has the same or a similar set of rules of recognition as we are? So it's more of an interplay between us and the other jurisdictions as well. So it's much more nuanced, because other jurisdictions like UK, US, they have wasted their time and now they have settled down. So they are at a stage of very advanced understanding of this issue. So but I think for us, we need to, I think, strengthen the domestic capabilities. One is the clarity of law, other is the institutional strength. So for example, our judges must be able to understand what is the implication of India being a commie for a foreign representative coming here and initiating it. So, and also whether commie itself is a good principle. Because recently I heard that there have been issues on considering even commie as the right principle. So that's one. Secondly, I think for the real estate, you are absolutely right. I think in the real estate also, this problem is acute because you have a land in one, you have a development right sitting in the other one. But fortunately, at least, I think we are coming to some sort of understanding as far as the real estates are concerned. They are not thinking the project as as a separate entity which is in the insolvency, and whatever is required to make that project as a viable or a reviable entity, I think that's what we must do that. If it involves pooling in the land owning company and the development company together, that's what we do. Thank you.
Any other question? Yeah?
Yes.
Thank you, Mr. Risham and Mr. Anoop. It has given us an idea as to how the cross-border and the group insolvency work. And it gives us an opportunity, like we can now have a lot of expectations that there's a lot of scope for us. On one side, we feel that the number of cases that are coming under insolvency are going to reduce, what will happen to the court. But now hearing you in these sessions, we find that there's a lot of scope for us to explore in this field of insolvency. And coming to Mr. Anoop, may I ask, what are the recent amendments that would have in the code, which would have a significant impact on the group insolvency? Are there amendments in the code already? I can understand that the unicitral and all that, we are still in the draft stage. That's what, if I can understand.
See, we do have a draft ready even for the group insolvency. But unlike the cross-border insolvency, which will primarily be driven by what is your legislative framework, for group insolvency, fortunately, you don't have to wait that long. And there are court orders, and courts are actually applying the judicial wisdom, as I said, as compared to the commercial wisdom of the COC, to see that whether in a fit case they should admit the consolidation. And this is where there's a lot of scope for innovation. There you can come up with good ideas. And instead of a very kind of a plain vanilla matter, you can actually bring in your innovative approaches for maximization. Maybe helping the lenders in planning things out. I think the Indian ecosystem is also changing very, very fast. From a stage where we actually had to handhold the lenders. I still remember we did Bhushan Steel in 2017-18, and at that point of time nobody knew what does it even mean? They were asking the resolution professional to make the payment of interest during the CRP period, and there was no clue as to, because even today there is no provision in the code that restrict the ability to service the debt, except that, you know, a principle has developed that you can't do a preferential payout. So from that stage, you have very, very, I would say, informed group of lenders. And I would also say that, you know, the intricacies and the complexities in the insolvency will now go to a next level. And you need to decide which place you want to be in. Whether you want to be in the ordinary places of, you know, asset-based insolvency, which very now will be kind of very, very ordinary work, or move on to a very complex areas of, you know, maybe the cryptocurrencies, okay, or maybe, you know, how in some of the IT segment, you know, the insolvency comes up. So I think insolvency is going to stay. Insolvency law is not a law how to bury the dead or how to, you know, kill this. But insolvency law is also, you know, how do you revive and how do you recirculate the capital. So therefore, you know, when the economy grows, there would be a moment when the economy slumps. And there, you know, you will have some events where some of these sectors will go down. You have seen go first, despite all of that thing that, you know, companies will not come into insolvency, go first did come. So going forward also you will have a lot of stress which will develop. And I hope that, you know, going forward we do not have the insolvencies coming out of the corporate governance issues or the sanctions, which have been primarily the flavor of the initial stages of insolvency law. I hope that going forward it is because of the economic reasons, which is a much healthier and better way to look at insolvency law, and I think it will stay. And once the pre-packs comes for the larger concerns, I think that is the point when the you know, you will again see a spurt of insolvency cases. So you need to keep on developing your own understanding of insolvency law and keep coming and bringing on the innovative ideas.
So much.
The last question we are taking is, we are running out of time.
Considering the innovative ideas that you are talking about, do you think we will see something like joint resolution professionals in future?
See, it could be anything, okay? As I said that, you know, we have play in the joints. Play in the joints means, you know, when you are going to the adjudicating authority under section 60 subsection 5 and you are proposing them the offers or the solutions, there it could be anything. It could be a joint RP. It could be a joint RP where, see, it could be that, you know, in one set of companies, the COs, the lenders, they are comfortable with one resolution professional, others is comfortable with the others. And instead of, you know, having one resolution professional for the entire, they can also have a coordinated processes and have the joint RPs. But you are saying joint RP for the single entity?
No, sir. There may not be required for a single entity, but for a group or maybe
yes,
there are more, assets are more in more than one country.
Oh yes. You see, even within a single entity, there could be an instance of a joint RPs. If let us say in a real estate project, you have two different projects under insolvency. You can have very well a situation where you can have two RPs, you know, working on the same. So I think all possibilities are there. So therefore, you know, whatever are your understandings, do not stick to that alone. They are not the reality. They will change in 2 months' time. So that's the best part of being in this profession in India, actually.
Thank you, friends. Insolvency, I would say, is an art than anything else. It's a kind of art. We need to pursue it very differently. If the cases are being handled in the way they should be, every case is different from the other case, and we have to apply our thought process, and that has to be done accordingly, and that is going to yield the results for us. Friends, lot many things are haunting these days. One, that new circular that is coming, or that the IBBI that has recommended the NCLTs to change the resolution professional, wherein there is no resolution arrived at and subsequently liquidator is to be appointed at, then invariably that liquidator has to be a separate person other than the person who is the RP. So that is again, and it is not necessarily on account of the RP that the process is not through. There may be n number of reasons. It is not purely the failure of the RP. Maybe the value that is supposed to be recovered is not being recovered, or whatsoever. N number of reasons may be there. Maybe the COC is not satisfied with the value that is being given, or whatsoever. So that also one thing that we need to look into. As a IP, we need to be as transparent as possible, and the documentation is the only thing that is come to our rescue actually. Whenever the things are in a bad shape, today morning also we were discussing, so that is only because of lack of documentation, I would say. That is very, very much important for all of us. And it's again a full-time business and not a part-time job kind of thing, that morning we are doing as an auditor, evening we are doing as a RP. No, that is not going to be possible. We have to be RP, means we have to be RPs, that kind of thing. My compliment to Ahmedabad branch under the leadership of Sunit Bhai, who has taken the lead for this one-day conference, wonderful conference being organized, and the two speakers for today, Risham ji and Anoop ji. Though the subject itself is very, very complicated, both, that is the cross-border as well as the group insolvency, the reason being most of us are not having any hands-on experience, practical experience on these particular two things. If it is insolvency, other than these two topics, yes, everybody is having some sort of experience and we can relate the things. But when it comes to cross-border and group insolvency, I would say it is very rare, only few people might have some hands on this. So you have explained it wonderfully, you have done great justice to the topic. Thank you, thanks a lot, thank you very much.